All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. This is the time set for argument in the matter of State of Arizona versus Mark William Clary, Jr., our criminal number 13-0694. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal. It's up to you to decide how much and whether you wish to do that, and to keep track of your time in that regard. We have read the briefs. We've been through the record. We have conferenced the case, so we're familiar with the facts and the arguments raised in the briefs. So keep that in mind as you make your arguments here this morning. The proceedings are being recorded by audio and video. So as you approach the podium, please identify yourself and your clients for any of those who may wish to listen or view the video. With that, Ms. Vopel, you may proceed.
Good morning. I'm Lori Vopel from Jones, Skelton, and Hockley, counsel for Mark William Clary, Jr., and I'd like to reserve 3 minutes for rebuttal this morning. This case involves a purposeful intrusion by the state's case agent, accident reconstructionist, and lead detective into the private attorney-client communications of Mr. Clary that involved discussions about alcohol that were unknown previously to the detective, discussions about case strategy, defense strategy, and facts of the evening. The detective then took this information that he had illegally, surreptitiously obtained and used that evidence in order to help the state obtain a grand jury indictment for second-degree murder and 8 search warrants, including for blood alcohol. In all of those, he lied and committed perjury by claiming that he had independently obtained the evidence of alcohol through his own observations. Given this detective's fundamentally central role in this case as case agent, accident reconstructionist, and the fact that he orchestrated this entire investigation, the intrusion in this case and the perjury so permeated this case that dismissal was required under Picard and Warner. Additionally, and Weatherford. Additionally, because the prosecution, upon learning about this purposeful intrusion and perjury before the grand jury, did not go and inform the grand jury that its indictment for second-degree murder, multiple counts, had been based upon, in part, upon perjury as to a material issue, alcohol, which the detective admitted he did not have probable cause for second-degree charges until he learned about that alcohol evidence. Because of that, it is independently required dismissal under Basurto.
The prosecutor learned about, when did the prosecutor learn that the case agent was lying?
When Judge Miles made his findings, Your Honor.
And that was after the grand jury had already issued the indictment?
That's correct, Judge.
The prosecutor couldn't have gone back to the grand jury at that point and revealed that, right? Absolutely,
they could have, and that occurred also in Basurto. In fact, that was the holding in Basurto.
How would they do that? If the indictment's already been handed down, then there's a motion. You'd have to dismiss the indictment and send it back down to the new grand jury, right?
That's correct, Your Honor. They would have to voluntarily dismiss the indictment and re-indict without any of the tainted testimony. That is correct, Your Honor. That's exactly what happened in Basurto and in these other cases.
And there was a motion to send it back down to the grand jury in this case?
Your Honor, they couldn't move for remand because it was so late in the game when the defense learned about when they got a hold of these tape recordings that demonstrated what Detective Seward had done. So all they could do was move to dismiss the indictment at that point. But the cases are very clear that once the prosecutor knows that a purposeful that an indictment is based partially on perjury to a material issue, which this unquestionably was, then there's an independent duty for the prosecutor to go back and re-indict. That is correct, Your Honor. And that did not occur here. And that is our position as to that issue. I think it's, if you look at all of these cases, the fact, and you can distinguish every one of these cases where that did not occur either.
I thought your argument was, and maybe I missed this, I thought your argument that the case should have been dismissed with prejudice.
Yes,
Not that
Judge.
it should have been sent back to the grand jury.
At this point, we believe because jeopardy has attached, that it should be dismissed with prejudice. And under Picard, that does require dismissal with prejudice where the case is so, and where the state cannot prove beyond a reasonable doubt that the intrusion and the taint has not permeated every aspect of the case, which this one has. I mean, much more so than any of these other cases. In fact, this puts it on all fours, I think, with U.S. versus Levy, where that's exactly what the court found and said, and that invasion was much, much worse, where basically the DEA agents, there were two co-defendants, and one of the co-defendants had become an agent or informant for the state on a completely different case. But that wasn't disclosed, but in the course of their discussions, the DEA agents had asked, hey, how's this case going? And he revealed some information, and that was enough. And because those same case agents were so involved and permeated the state's case, that is why in Levy they found that it had to be dismissed with prejudice. And all of the cases, Your Honors, cited by the state, cited by us, if you look at those, the cases that are distinct where it wasn't dismissed, either it was unclear, so it was remanded for evidentiary hearings as to whether it was purposeful or deliberate, which Picard uses those, Judge Gerber uses those terms interchangeably. They're the same thing. Or it was clear that either it wasn't purposeful, or it was, an inadvertent misrepresentation, or it didn't go in Moody, for example, to a material issue in the case, or defense strategy was not learned. Here, just as in Levy, the unrefuted, uncontroverted testimony by the defense was that they discussed defense strategy. And you cannot trust that anything happening from that point forward in that case, given this detective's central role, was trustworthy in any way, shape, or form. Now, at a very minimum, as we said, and this is laid out pretty thoroughly, even the cases that say, well, we're not going to dismiss with prejudice, even those say every single piece of evidence that is obtained through that and tainted, essentially, through that violation must be suppressed. And Levy and even Rosengren demonstrate that the Fourth Amendment principles of inevitable discovery do not apply in this context, because the Sixth Amendment violation and the right to consult with counsel in private is so fundamental to our system and our adversarial system, especially in a criminal case, that you can't let the state get around those sanctions. A severe sanction is required, and it either has to be dismissal with prejudice or suppression of every single piece of evidence that was tainted, and that did not occur here.
You have to assume it was tainted, right? You have to find that it was tainted. And for instance, if the police say, we would have taken the car chips anyway, we would have taken the DNA sample anyway,
That's independent.
That's independent, right?
That is under the that's under the inevitable discovery doctrine, Your Honor, and that's what I'm saying is that Levy and Rosengren in these cases show that because these are sanctions, it's one thing if they were in fact independently obtained. That didn't occur here. The court applied Fourth Amendment analysis.
That there was probable cause to believe that he caused the accident, forgetting what they heard on the tapes, what they heard on the telephone conversation. My recollection is that the police said, listen, because we wasn't a driver in the car, we wanted to get the DNA samples. Because this was a very severe accident, we wanted to get the paint chips. All of that would have been independent. I mean, isn't that something that the court could have found that it was independent?
Your Honor, if they independently obtained that, that's one thing. But they didn't. In other words, what I'm saying to you, Your Honor, is that to say, well, we would have, we could have, that's the inevitable discovery in the independent source doctrine. According to Levy and Rosengren in these other cases, that is inapplicable when you have this kind of a purposeful intrusion into the Sixth Amendment. Those are Fourth Amendment principles, Your Honor. It's different. Now, reversible constitutional error also occurred in this case due to the same detective who did this accident reconstruction, the trial court allowing him to testify regarding the conclusions of a report, a crash data retrieval report taken from Mr. Clary's airbag control module. Mr. Seward, Detective Seward, and if you compare this case and his qualifications to the cases that are cited by the state and the type of experts that are required to lay foundation for this kind of evidence, there is no comparison whatsoever. Mr. Seward, Detective Seward, testified. All he knew how to do, all he was trained to do, was to plug in his computer, download part of the hexadecimal data from this airbag control module, and generate, using his computer program, a report that said that Mr. Clary was going in excess of like 142 miles an hour. That, if you look at these cases, and in particular, I would like to point the court's attention to Bachman, Safka, and Matos. We are talking about engineers who worked for the manufacturers of the modules and or the manufacturer of the vehicle, who were familiar with the inner workings of these modules, who could say, who could read this data. They didn't just report the conclusions of a report. They were able to independently verify the data and verify that that particular module was working on that particular occasion, and that evidence was considered reliable. That is not what occurred here. Detective Seward, by his own admission, had no clue how this worked. He could not read the data. And there's just no comparison, Your Honors. That should not have come in. He was not qualified to lay the foundation. And because of that, it was impossible for the defense to adequately cross-examine Detective Seward regarding the conclusions of this CDR report, because he was unqualified. And so therefore it violated his Confrontation Clause rights.
Help me understand the Confrontation Clause claim that you make.
Your Honor, the cases from Bullcoming to, excuse me if I can just get to that very quickly.
Michigan versus Bryant.
Bullcoming, exactly.
You've got a series there, but all of those involve something other than the product of a electronic device analyzing something without human input. It seems to me that those are different.
Actually, the cases that I just cited, the state court cases that apply these very cases, say it is no different. They went through this analysis, Your Honor.
Help me out, though, on the confrontation. There has to be a statement by a person.
No.
that was not made available. Tell me what
That's
that is.
not accurate. According to Melendez-Diaz, Bull Cumming, Williams, and Davis, they found that documents
Right.
are testimonial.
Based on personal input. And we don't have that here. I understand the context of those cases, but this seems to be very different.
Well, Your Honor, this is more like, frankly, a report and information, which some of these cases and some of the other cases look at. For example, a blood alcohol, test.
You've got somebody inputting, though, and then there's an output. Who should have been called to testify here that you say was
According to these other cases that are cited by the state,
if
engineers
those provide the analysis that
engineers who could testify regarding the data. It's the report that we have a problem with here.
Who would that be? I mean,
Your Honor, it would be similar to the experts that were involved in these other cases who understood the workings of these devices, could explain and could read the data, as opposed to just some report that is generated by a computer.
But so
and who could
your
determine
argument is that it is the person that could understand the data who should have been called, not somebody who was involved in the data being created.
That's correct. And part of it being downloaded for a prosecutorial purpose. That's correct, Your Honor.
That seems to be very different than the Bull Cumming case.
Your Honor, I think it's worse than in the Bull Cumming case.
I understand that.
Because in those cases, again, you do not have a situation where no one knows whether this device is working properly, where the manufacturer itself says that this information is unreliable and that is not responsible for any kind of problems with a download or inaccurate reading, et cetera, even more so than in these other cases. This is trial by airbag control module. And what's worse is that unlike these other cases, you don't have a situation where this is akin to a black box. Even Detective Seward testified that that's not akin to the type of black box or event data recorder like in these other cases. So the reliability of this particular kind of evidence has not even been established, to my knowledge, anywhere, and certainly not in Arizona. And because of that, under Daubert, under Rule 702, the reliability, the admissibility, and this detective's ability to lay the foundation to establish its admissibility and reliability was missing in this case. And that's critical, Your Honor. And so I think it's worse than the other situations.
So by definition, your position is that the CDR report was testimonial?
Yes, Your Honor. Absolutely. This is not the data. These other cases involved data where then that data, and if you look, for example, in the substitute expert, and where that information can come in, where the data was used and relied on, for example, by the testifying expert, who then could not still testify as to its conclusions and opinions like occurred here.
I struggle with, and I think we're where we will be, is that typically, though, there is somebody who inputs that data, and here there was no such person.
Your Honor, there is a computer program that was used by Detective Seward that downloads part of the hexadecimal data from a machine that he admits is not primarily for the purpose of determining speed, all these other critical issues in this case, who then could not testify as to how this occurs or give any kind of a foundation to establish the reliability of this report. It's not the data that then he came in and read. It is a report that said, and that then the judge allowed the state, notwithstanding her ruling, to use as substantive evidence to say that this CDR report said Mr. Clary was going speeds up to 142 miles per hour. That is highly prejudicial, and to have absolutely no foundation regarding that this ACM was working properly, especially where there were warning lights coming on, and to what the remaining hexadecimal data that was not downloaded might have said about whether the ACM was functioning properly is completely not allowed, especially when you have a witness and a computer report that cannot be tested under the Constitution through cross-examination. That's just not allowed under our Constitution, Your Honor. And it's not allowed under Daubert. And even these other cases, there were challenges under Fry as to whether these highly qualified experts could come in and lay the foundation for that very same type of evidence, Your Honor.
With the Confrontation Clause issue, saying the state should have brought in the computer programmer?
I think the state should have brought in a person. For example, I think an airbag control module expert, or somebody who is an expert and familiar with this type of airbag control module and with how a CDR report is prepared. I see I'm running out of time, Your Honor, and I would like to save some time for rebuttal. But an engineer, something far beyond an accident reconstructionist who can download it.
Wilson.
May it please the Court, Assistant Attorney General Lindley Wilson on behalf of the State of Arizona in this matter. If it's all right with the Court, I'd just like to address the arguments in the order that appellant addressed them. Regarding the first issue, there was no elaboration at the evidentiary hearing about any case strategy that was discussed or intercepted by the officers in this matter. Appellant had every incentive to elaborate on that claim below, but the extent of the testimony was that there was some legal strategy discussed, which the most reasonable inference in this case is that appellant's attorneys were advising him not to make statements. This is occurring at the very preliminary stages of the investigation, so there's simply no evidence that the state intercepted any legal strategy from the defendant's phone call. Also, there's no express finding of perjury, and at no point after the evidentiary hearing did appellant request any relief under Bracerto. And we think that that's important because in Moody, for example, which predated Henderson, the defendant did preserve a Bracerto claim below, and so it enabled the parties to further discuss that claim and to, make any findings about what the prosecutor's obligation was under Bracerto. And as we've argued in our brief, there was no finding of perjury here, but even if we could see any sort of implicit finding of perjury, that wasn't material to the grand jury's decision to indict appellant on these very serious crimes.
Why is that?
As we've detailed in our brief, the grand jury heard overwhelming evidence of all of the circumstances of this case, including the fact that there are 2 dead victims on the freeway, that this was a very complex reconstruction scene, that defendant was seen fleeing the vehicle and chased by witnesses, the 911 calls. There was just overwhelming evidence, and in fact, the later jury's determination of guilt on these charges shows that the grand jury necessarily had probable cause to issue the indictment, notwithstanding this alleged perjury here.
What's your response to the argument that the inevitable discovery and independent source rules just don't apply?
I believe they absolutely do apply in this context, and a case standing for that principle is State versus Hackman, 189 Arizona 505, and that's from the Court of Appeals, 1997.
I'm sorry, Counsel, 189
Sure.
Arizona.
I'm sorry, 189 Arizona 505.
It's Hackman?
Hackman, yes. And that's holding that inevitable discovery and the independent source doctrine applies in the Sixth Amendment context. But, notwithstanding the availability of that case, another way of viewing this is, did the officers actually obtain this other evidence by virtue of the Sixth Amendment violation. They did not. There was testimony at the evidentiary hearing that they would have gotten his DNA, a DNA sample. They were intended to test all this evidence all along. So that really goes to the trial court's determination that the only benefit they received from this intrusion on the phone call was the fact that alcohol might have been involved. And this court should defer to that factual finding by the trial court that the extent of the benefit derived was just the alcohol. And that's the most reasonable inference from the record. The trial court made all of the requisite findings under Picard that it was required to. I think it's also important to remember that in Picard, there was repeated and ongoing deliberate, intentional misconduct by the sheriff's office. That was phone calls that involved them recording phone calls to the defendant's attorney from the jail and opening privileged legal materials in jail over a period of months. And in that case, this court held that the trial court, in fact, abused its discretion by just dismissing all of the charges without considering lesser remedies. So this certainly is a less culpable Sixth Amendment violation, and the trial court did exactly what it was required to do under Picard and all of the case law that we've cited. Moving on to the second issue, admission of the CDR evidence. As we've argued in our brief, this CDR report is not testimonial, and it wasn't even admitted as substantive evidence, which is very important. Under Williams, the Supreme Court held that the admission of evidence just to support an expert opinion does not even implicate the Confrontation Clause, and this court reaffirmed that principle in Karp very recently in 2014. So for that reason alone, it doesn't implicate the Confrontation Clause. Further, it's not testimonial. There's no statement by a person at issue here. There's been an attempt by appellant to distinguish the technology from the cases that we cited in our brief on this exact issue, and that distinction is unpersuasive. This is the exact type of technology that other courts have deemed admissible and non-testimonial and do not implicate a defendant's Confrontation Clause rights. One other thing I just wanted to alert the court to is that at the mid-trial motion that was conducted on the admissibility of this evidence, the trial court considered 7 exhibits at that hearing, which included Sywert's resume, his, I believe, 2 or 3 certifications about his qualifications to download this type of data, and also 2 articles discussing the admissibility of this and reliability of this type of evidence in collision reconstructions. So it made all of the requisite findings under Daubert, and so the reliability challenges were fully litigated in the middle of trial. And then defendant also had an opportunity to cross-examine Sywert, and he did so for about 3.5 days, challenging his credentials, his qualifications, and the overall reliability of this kind of information. So the trial court made its requisite findings under Rule 702, and then the jury was also permitted to consider whether Sywert's reliance on this type of data was reasonable.
Ms. Lindley, can you give us that citation again, the 2014 case you referenced?
Sure, that's Karp, and that is, let's see, 236 Arizona 120.
Yeah.
And that's from October 2014. Does the court have any other questions regarding those issues or any of the other issues raised in the briefs?
Question? No. Thank you, counsel.
We would rest on our briefs and request this court to affirm appellant's convictions and sentences. Thank you.
Ms. Vogel, we're going to give you 2 minutes.
Thank you, Your Honor. First of all, to say that Mr. Clary was required to lay out what defense strategy was discussed is completely not required under these cases and would require them to violate their confidences further. That's just not required. There was testimony, and it's clear that it was. That is sufficient under these cases. There's no need for him to request, and under many of these other cases, under Basurto, for him to request that the prosecutor go back to the grand jury. As I said, it was too late to file a 12.9 motion, and the prosecutor had an independent duty to go back. As for the idea that the other evidence could be sufficient to uphold the grand jury indictment was completely dismissed by these other cases that we have cited that demonstrate that you don't look at the sufficiency of the evidence. Here, even if you did, Seward said he did not have probable cause to charge for second-degree murder, which changed the entire trajectory of this case. Okay, it really did. He did not have probable cause without the alcohol evidence. So that certainly is not true here. In Picard, that was remanded for specific findings. The trial court there thought that dismissal was the only option. And so what Picard said was, you can still dismiss if all of these if the state cannot prove beyond a reasonable doubt that this wasn't so pervasively tainted that the prosecution could go forward with suppression. But that, they just remanded. As far as the CDR report, Karp and Williams and these other cases are clearly distinct because of the fact that the conclusions are not allowed to come in. The conclusions and opinions were not allowed to come in. The data could be relied upon in forming their own conclusions. Here, that's not what happened with Seward. And when you combined this evidence coming in, it completely destroyed any gains that they made from cross-examining Seward's credibility and qualifications, and especially when then they were not allowed to fully impeach Deborah Higuera and bring in the reliable testimony that said he was traveling 75 miles per hour or more than or 10 miles per hour or more than their 65 miles per hour. This went to the very heart of this case and the issue of speed, and it violated his due process rights.
Thank you, Ms. Fulton. Thank you, counsel, both of you, for your arguments here this morning. We're going to take this matter under advisement. We'll issue a written decision in due course. We stand adjourned. Thank you.